One of the most common claims that you'll come across in the employment relationship in Ireland, in employment law, is unfair dismissal. This includes constructive dismissal. In this video, I'm going to take a look at 15 things that you need to know about unfair dismissal in Ireland. Okay, the first thing that you need to know is that the relevant legislation is the Unfair Dismissals Act 1977, and this was amended by the Unfair Dismissals Amendment Act of 1993 and some other amendments since that. But the essential starting point, if you want to find out about unfair dismissal and see what the law actually states, is to go to the statute book, irishstatutebook.ie, and look at the Unfair Dismissals Act 1977. Second thing you need to know is that unfair dismissal arises when the employer terminates the employment of the employee. A constructive dismissal, on the other hand, is where the employee terminates the employment relationship, and the employee would be doing so on the basis that the behaviour of the employer is so bad, so egregious, that he or she can no longer be expected to put up with it and therefore resigns from the position. There's a huge and significant difference between the two positions. The unfair dismissal, where the employer dismisses the employee, means that the burden of proof to show that it was a fair dismissal rests with the employer. In a constructive dismissal situation, however, the burden of proof rests with the employee to prove that he or she has acted reasonably and that the conduct of the employer has been so bad that essentially the employer has considered the employment contract at an end and the employee is therefore entitled to resign. The third point you need to know about an unfair dismissal or constructive dismissal claim is that most times, 90%, 95%, 98% of the time, you must bring your claim within 6 months of dismissal. You bring your claim to the Workplace Relations Commission, not to court but to the WRC, and it must be within the time period of 6 months. Number 4, redress is possible is reinstatement, re-engagement or financial compensation. Number 5, financial compensation is limited to actual financial loss. So if you are fired out of one job and a month later you get a new job, then strictly speaking your financial loss is 1 month's salary. That is the gap between getting fired and getting the new job, and that is all you're entitled to according to the legislation, and that is all the WRC can award you. You cannot be awarded anything for embarrassment or pain and suffering or for rough management or for defamatory remarks or anything like that. They cannot be dealt with in the WRC. In the Workplace Relations Commission, you're entitled to financial loss under the legislation, that's it. If you've been defamed or if something else has happened to you, then you may need to go someplace else. For example, if it's defamation or slander or anything of that nature, you really need to go to the civil courts. Sixth thing, an employee on probation can be dismissed without any great protection and does not have the protection of the Unfair Dismissals Act. So if you are on probation and if you've been fired, then to all intents and purposes you can forget about bringing a claim for unfair dismissal, unless your claim is based on a dismissal on one of the discriminatory grounds, in which case you don't need 12 months service. You can bring a claim, but by and large, in order to bring a claim, you need 12 months service, and if you're on probation, your probation period cannot exceed 12 months. Therefore, if you're on probation and you're fired, you really are flogging a dead horse trying to bring a claim for unfair dismissal. Number 7, the position or the starting position in the law is that a dismissal is generally seen as an unfair dismissal unless the employer can prove otherwise. So the burden of proof is on the employer to prove that it was a fair dismissal. Number 9, an employer is supposed to give an employee a written statement within 28 days of starting the job of the dismissal procedure. Number 10, you can go to the courts and bring a claim for wrongful dismissal. Wrongful dismissal is essentially a breach of contract claim, but you can't go to the WRC with an unfair dismissal claim and to the civil courts for a wrongful dismissal claim. You really must choose between one or the other. Going to court is more expensive than going to the WRC. If you're an employer and you're going to dismiss on the grounds of competence or incompetence, you really do need to go through some sort of a performance improvement plan, or at least give the employee the shortcomings. Let him know or let her know what the shortcomings are and give him or her sufficient time to improve. Only then, after a reasonable time, and I would suggest 6 months is probably reasonable, only then can you dismiss on the grounds of incompetence. But you do need to set out, number one, what the shortcomings are, and number two, the time frame within which they can improve, and number three, the required improvement, and the employee should be given training and assistance to improve and to do the job. The incompetence ground or competence ground can't be used as a way just to get rid of an employee that you don't like. You do have to be fair and give them fair procedures. That brings me on to my next point, number 12. Even if an employee is going to be dismissed for competence or indeed for any other ground, by and large you do need to give them fair procedures and natural justice. So you need to bring them through some sort of a procedure. There is a statutory instrument 146 of 2000, which sets out a basic disciplinary procedure that should be used in the workplace. And basic fair play should be used, and each employee has a right, a constitutional right to fair procedure, natural justice or constitutional. An employee on long-term sick leave can be dismissed on the basis or on the grounds of incapacity. In other words, he or she is no longer able to do the job they were employed to do. However, this needs to be very, very carefully handled from an employer's point of view, and you do need medical evidence, and you do need to give them sufficient time to recover, and you do need to have sufficient medical grounds to terminate the employment on the basis that the person is not going to be able to return to do the job that they were entitled or that they were taken on or contracted to do. So essentially the contract is frustrated. It's finished, through no fault of anybody's. The employee is simply sick and or has some illness that prevents them from doing the job that they were taken on to do. The WRC or the Labour Court, in looking at a constructive dismissal case, will apply two well-known tests in deciding whether the employee was justified in leaving the job or not. One, did they act reasonably? And they'll also look at the conduct of the employer to see whether they acted reasonably. And two, the contract test. Was the conduct of the employer so bad that the employee was able to reasonably deduce that the contract was no longer going to be bound or binding on the employer? So they are the two tests in a constructive dismissal case: reasonableness of the parties and contract. Was the contract essentially broken by the employer, and was the employee essentially therefore let off and allowed to resign and bring a claim for constructive dismissal? The 15th and final point I would make is that many, many famous people have A, gone bankrupt, and B, been fired. It's not a life-changing event for most of them. People recover, people go on to great things. Sometimes a job isn't just for you, sometimes the employer just isn't for you, and quite frankly, as an employer, an employee may well not be just the right person for your business or your organisation or whatever, but an unfair dismissal or the termination of employment is not a life-changing or shouldn't be a life-changing event. It should be just a bump in the road, a speed bump as it were. Hope you find this video useful. If you do, you might share it with your friends, give it a thumbs up down below, and subscribe to my YouTube channel. Thanks for watching.